Mr. Andrew Khoo is also a practicing lawyer, which is why I also have this question for Mr. Khoo. We have heard how there are existing laws in place, such as the PCA, SOSMA, POTA, Penal Code, but can it not be argued that it is not sufficient to cover the event which requires swift action, like Lahat Datu? Because where I'm coming from is this. Under POTA, there's actually quite a lot of bureaucracy that you have to go through before anything can be done. But under the National Security Bill, it seems that action can be taken quite quickly. So is it really true that existing laws are sufficient?
I'm going to answer the moderator's question eventually. I want to take a little journey to get that. Like many people, I too have been asking, why this bill? Why now? I think these are the key questions that everybody is asking. And the lack of a narrative from the government, the lack of any story to tell you why this is necessary, apart from patchwork stories here and there, to me is very worrying. Because as the MPs would say, it was rushed through Parliament. I would use the phrase indecent haste. In which it was done, unholy, indecent, whatever, pick your words. And I also wrote here somewhere, the dark descent into despotism. So the question is why? And I would like to share this with you. This is my personal thinking, so it's not the view of the bar. I have to tell you that, just in case my bar counsel says, Andrew, why you go and say things like that? This is my personal view. Let's look at some of the things that have been happening recently. One is, you could argue, a resurgence of leadership by the sultans, the traditional rulers. Okay? You have some very clear examples in the south, but as you look at the next few states who opt to be the Agong as you go through the cycle, after Tuanku Halim, it will be the Sultan of Kelantan, if you go by the order that was set, then the Sultan of Pahang, then the Sultan of Johor, and the Sultan of Perak. And if you look back in the past, you can see that sometimes when certain states come to become Agungs, there are misgivings about the relationship between the executive and the institution of the monarchy. So when we see the resurgence, say in Johor, for example, I'm wondering whether somebody sort of said, is there going to be a problem? Because YB Hanipah did mention it, but I don't think we really fully understand it. Article 150, we talk about Article 150 of the Constitution, right? Proclamation of emergency. It says in clause 1, if the young di Pertuan Agong is satisfied. Now, some people may argue, okay, is that a prerogative of the Yang di Pertuan Agong, or does he have to act on advice? Because if you look at the powers of the Yang di Pertuan Agong, it basically says that, this is Article 40, Clause 2, the Yang di Pertuan Agong may act in his discretion in the performance of the following functions. That is to say, the appointment of a Prime Minister, the withholding of consent to request for a dissolution of Parliament, requisition of meeting or conference of rulers, and then it has a catch-all, and in any other case mentioned in this Constitution. So some people may take the argument, oh well, Article 150 is not mentioned, so he doesn't have the prerogative, he has to follow the advice of Cabinet. But as YB Hanipah has said, that's not quite true, because when you look at Article 150, as I said, the opening words, if the Yang di Pertuan Agong is satisfied. And then 150 Clause 8 says basically that you cannot challenge the satisfaction of the Yang di Pertuan Agong. So the declaration of emergency depends very much on the individual satisfaction of the young di Pertuan Agong, whoever he is at that point in time. So, somebody say, well, you don't need National Security Council bill because you have a proclamation of emergency. But what if the government going to the young di Pertuan Agong said, we want you to declare an emergency? The young di Pertuan Agong says, no. You can't challenge that, right? So if there is a, poor relationship between the executive and the young di Pertuan Agong at that point in time, there is a possibility, and I'm only going to put it as a possibility, that the young di Pertuan Agong at that point in time may disagree with the executive, the Prime Minister of the day, and say, no, I'm not going to agree to your request. I am not going to declare emergency. What happens then? You can't have an emergency. You can't have this alternative. So it seems to me that one of the reasons could be why this bill is being tabled now is planning ahead. If we have to encounter the possibility that somebody occupying the office of the young di Pertuan Agong is not going to agree, we've got to find another mechanism to create, and we won't use the word emergency because obviously they've been advised quite correctly. They start using the word emergency, we will immediately say this is ultra vires the Constitution. So they have to say something less than emergency. They cannot use the word emergency. So they talk about security threat, never define what it is, right? So it's open-ended sort of thing. So that's one thing. The other reason is the courts. Now, we have questions about the courts and whether the courts, the kind of decisions that they come up with. But think of two sort of recent incidents about court decisions. One is the earlier decision on the Peaceful Assembly Act, not the later one, the earlier one, where the Court of Appeal basically said you can't criminalize the failure to give 10 days advance notice for peaceful assembly. Right? So remember, the government tried to regulate the having of peaceful assemblies, and here was the courts frustrating the government's legislative agenda in a sense by saying you can't do this. Of course, now we have a second Court of Appeal decision which is totally opposite, so now we'll have to wait till somebody else is charged. Maybe, I don't know what's this, or Azmi. So, Azmi seems to be quite happy being charged, so the next one. To challenge, which is the right decision, and that will have to go to the federal court because you've got two conflicting decisions. Then recently, the attempt to charge Dato' Khairuddin and Matthias Chang as a security offence it's the arrest under SOSMA. It's not the charging. You don't charge people under SOSMA. Okay, let's be clear about that. But to categorize what they did as a security offence, to say that this was sabotage or attempted sabotage of the banking and financial system, the court said no. So again, you've got another instance where the courts have frustrated the legislative intent of the government. So while at other times you may think that the courts are very cooperative with the government, what if at one particular point in time the courts come up with a decision that goes against the government? So the government has to watch out for the courts. Government has to watch out for the monarchy, right? So what better way to avoid any potential problems from all this than by coming up with an alternative mechanism whereby the Prime Minister, without the need to get any approval from the young di Pertuan Agong or consent or agreement, and not to be challenged in the courts, comes up with an alternative mechanism to declare what in effect is, we all know, an emergency. Just that you don't use the word. So I think, personally, that's my view. I think this is why it's happening now. It's getting ready for the possibility sometime in the not too distant future where these things may well happen and they need to find something to override all that. And what better way than this? Okay? Some people talk about Sulu. I think that's a red herring. Okay? I honestly think that's a red herring because the East Sabah Security Zone was set up under Sabah state legislation. It's not set up under federal law. Okay? And secondly, the Sabah Security Zone legislation says that you need the Agong to declare a security zone in Sabah. That's in the Prevention of Public Security Ordinance of 1962 in Sabah. It goes back to the Agong. So you see, if you go back to the Agong, that's the problem, isn't it? What if the Agong doesn't agree with you, right? So this is an alternative mechanism where you don't, it would appear that you don't need the consent or the agreement, the concurrence of the Agong. So to me, that's the main thing that we are all missing. You know, why is this happening? And then of course you have the other problems. So I think that answers the question that the moderator put to me. If we already seem to have enough laws, why do we need this? Well, my answer is because all those laws have got issues whereby a very active judiciary and active monarchy can frustrate the intentions of the executive. This is a way to get around it. And of course there are other ways that in which we should be afraid of this particular bill. There are no safeguards, no checks and balances. All the people on the Security Council are people appointed by the Prime Minister, the cabinet ministers. So cabinet ministers are appointed in the name of the Yang Tuan Agong, but on the recommendation of the Prime Minister. And even the head of the armed forces, the head of the police, the chief secretary, again, they have the concurrence of the rulers must be there for them. But once they are appointed, they basically listen to either the Prime Minister or the Minister of Home Affairs. So they're not independent, they will not challenge the decision of their political masters, so there's no effective check and balance. Then you've got whole sections that provide immunity to the security forces for anything that is done that is wrong. Right? So you have this good faith defense that's been put in section 38 of the bill. So any security force member, if acting in good faith, right? You don't define what good faith is, you have no idea, okay? Acting in good faith, does anything or fails to do anything. This is very interesting. This immunity is an immunity not just on action, but on inaction and omission. So if you fail to do anything, you're also, in good faith, you're also given this immunity. And the danger with immunities is that it creates an environment of impunity. And we have seen how weakly and badly we act as a check and balance on some of our law enforcement agencies when it comes to actions and omissions. So this is a major weakness. Then the other thing that the security forces can do is that they can use reasonable force. But of course, reasonable force is proportionate to what they see as the threat. So if you think that someone is going to bomb some place, it can be argued, it's a legal argument, it can be argued that proportional force, reasonable force, can include torture. Because you need to squeeze the information out of this guy, because if you don't get information, maybe there's a bomb that's going to go off somewhere, and it's going to injure people. So it legitimizes torture. We in civil society, we at the Bar Council, we are asking the government to sign the Convention Against Torture in the UN, right? Here is a bill that will allow the government, in the name of reasonable force, to use effectively torture. And then finally, for now, the idea that this state of security, this security area, the Prime Minister declares it for 6 months, but can be renewed indefinitely. Indefinitely. It can go on and on and on. And we know, when we look at declarations of emergency, how long they have lasted. We had emergency for May 13, it went on from 1969 to 2012. We have declarations of emergency in Sarawak, in Kelantan, from 1960s, 1977 in Kelantan, went on till 2012. So, you know, the idea that, oh, it's only 6 months, don't worry, I renew a few times, never mind. But it can go on for 20, 30 years. There's a state of emergency. And remember, once there is a state of, well, I won't call it emergency, once there's a security situation, then the police, the security forces have all these powers which are unchecked. And so the danger of abuse is so real and so potent, not theoretically, because we have seen how these things have been abused in the past. So, you know, once bitten, twice shy, right? We've already seen there's a track record of abuse. So we cannot say that, well, trust me. We can't. There is a trust deficit. There's a yawning trust deficit which the government has not been able to bridge in terms of confidence in trusting them to do what is right. Okay, so these are some of my concerns which I share with you. I hope you can sleep tonight and not have too many nightmares, but this is, for the moment, my contribution to the discussion this evening. Thank you.